Trademark applications, what to expect. So a lot of people are misled by the word application and think it's sort of like when you buy a URL or something and you fill out the form and you pay the money and then you just get it. So they assume that as long as you fill out the form correctly and you didn't leave something blank, and as long as you paid the money, you should be able to get it, it should be granted, and that should be that simple. That is not actually how trademark applications work. So here's what to expect. Once you file your trademark application, it will go into a queue where it will get assigned to an examiner. That will take months and months. And in the meantime, once you file, you actually do have priority, U.S. priority, which means, I have some other videos talking about this, it means that you are in line, and anyone that files after you will get blocked by your application. It also means that anyone adopting the mark after your filing date will be subject to you being able to force them to stop using the mark, because once your application is filed, you have, national priority to that trademark. So, but you're not going to get anything. You'll get something saying your application's been filed, as soon as you file it. But you won't really see much happening until your application is assigned to an examiner, which, like I said, it'll take 8 months probably, at least. That's about the average. Then that person, it's a human being, it's not a computer, not yet anyway, in 2025. It's a human being whose job it is to find reasons to push back and to make you fight for your application and to try to limit the rights that you're claiming in various different technical ways. So I am telling people these days to expect at least one office action, and this is just the reality of it. Unless you've picked a made-up word, chances are there's going to be an office action. And keep in mind that you're dealing with a person, and they have a system at the USPTO that incentivizes examiners to push back. They get points that go toward promotions for certain kinds of pushback. And the reason for it, it's not because they don't like you, it's because a trademark is potentially a monopoly on the use of certain words forever in connection with certain businesses. And they don't want to just grant those to anyone who applies. They want to push back and make you fight for it. So, and just make sure it's limited, so that you're not getting rights that you're not entitled to. So that's the process. You should expect one office action. If you don't, that's great. Then you got through, and you should have a little money left over in your budget. But the important thing is to not expect that it will just go through with no pushback at all. Sometimes it's very, very minor pushback that we can resolve with a phone call. Sometimes it is more than that, and you can still get your trademark registered, but you just have to overcome some hurdles. If you have done real trademark clearance with a real trademark attorney, they will, after clearance, be able to tell you what to expect. And you shouldn't be going blind upon filing. So I highly recommend, this is another reason to make sure that you do clearance, real trademark clearance, not some computer engine that says, hey, it's available. Those aren't real because it's a nuanced decision that whether something is available or not, and two humans may disagree. So I don't think they've written an AI program that's going to be reliable in that. You should have your clearance done by a real trademark attorney who you can actually talk to, who will give you advice based on what they found, so that you know what to expect upon filing. And if they say it's going to be a real hard fight to get that trademark registered, then at least you know ahead of time, and you can maybe not choose that name. Choose a different name that's not so much of a fight. So anyway, hopefully that was helpful. Catherine Cavella, IP Works Law. Thanks.